To learn more about earning college credits with study hall courses, go to gostudyhall.com or click the link in the description. Are you currently furious with the Supreme Court? If so, you're not alone. According to Gallup, more than 50% of people have consistently disapproved of the court since September 2021. If we just skip over the past few years' worth of ethical scandals and partisan decisions, the court has historically been highly respected. It used to get higher approval ratings than Congress, which is surprising because justices aren't elected by the people, while Congress is. But the Supreme Court's power is concentrated in 9 justices who make decisions that affect millions of people on topics ranging from abortion access to voting rights to campaign financing. It's the Supreme Court's job to help balance the government by checking the power of the legislative and executive branches, and to interpret laws for everyone else. But lots of people in the United States question whether that's what's really happening, or if the Supreme Court is just another place in government highlighting an imbalance of power and partisan decision-making. Hi, I'm Carmela Boykin, and this is Study Hall, Power and Politics in U.S. Government. So what's the Supreme Court supposed to be doing? Well, the Supreme Court is part of the judicial branch of the government, which was established by Article 3 of the Constitution. While the first 2 articles establish the legislative and executive branches, the third outlines the court's authority. But Article 3 is relatively vague and short at just under 400 words. For comparison, Article 1 is around 2,300 words, and Article 2 is just about 1,000 words. In fact, one of the court's most popular powers doesn't even come from the Constitution. It comes from the court's own decision in Marbury v. Madison 15 years after the Constitution was ratified. That power is called judicial review, and it means that the court can strike down legislative or executive actions as unconstitutional, which is how they check and balance the other branches. What is stated in the Constitution is that the Supreme Court can get cases in 2 different ways: original jurisdiction and appellate jurisdiction. Original jurisdiction means they're the first and only court to hear a case. That's usually limited to legal disputes between states or other cases that go beyond the reach of lower-level courts. For example, starting in the 1950s, Arizona and California fought over how much water they should each get from the Colorado River, and the Supreme Court used its original jurisdiction to hear the case. But the court gets the majority of its work from their appellate jurisdiction, which is when they hear a case if the decision of a lower court is appealed. In appellate cases, the Supreme Court's ruling takes precedence over the decisions of lower courts. That's because federal and state courts get their commands or understanding of the Constitution from the Supreme Court itself. This hierarchy is reminiscent of the Constitution's Supremacy Clause, which mandates that a federal act is superior to state laws. But with the U.S.'s dual court system, federal courts operate in tandem with state courts. So, if you break a state law, your case would be heard in the state court, and for a federal law, a federal court. In both state and federal governments, there are 3 layers of courts, which focus on different things for different purposes. So, say a business is accused of discriminating against certain customers. The case would first be addressed in a district, or trial court, where the main goal is to determine the facts of a case. They would try to figure out exactly what the company's policies are and what has happened when the business interacts with customers. If the judge rules that the business was in fact discriminating, the business can appeal that decision and take the case to the next level, the appellate court. These courts take the case and look at more legal questions, like if the district ruling was awarded appropriately or if there was enough evidence to determine their ruling. They generally do not gather new evidence or retry the case. Instead, they determine whether there were problems with the initial case that affected the outcome. In the appellate court, the case may be heard by multiple judges who vote to determine the ruling. If the business again wants to challenge the ruling, they can bring the case to the court of last resort. This is the highest court with the most authority. In the U.S. federal court system, that's our Supreme Court. They clarify or review decisions of lower courts and operate in more complex areas, like international disputes. To go to the Supreme Court, the business's legal team would need to petition for a writ of certiorari, or cert. Around 7,000 cert petitions are filed each year. So it's kind of like shouting into the void, because the Supreme Court can only hear about 100 to 150 of those cases a year. To get on the docket, at least 4 justices need to agree to review the case, according to the Rule of 4. So, getting to the Supreme Court is easier said than done. With so many certs coming in, justices are most likely to take on cases that might have nationwide consequences. For example, some of the court's recent cases involve abortion access, which affects people all over the country. Like in April 2023, district court judges in Texas and Washington state both heard cases involving mifepristone, one of the two medications used for medical abortion and miscarriage. About 60% of abortions in the first 10 weeks of pregnancy are managed with medication, and up to 1/3 of pregnancies end in miscarriage, which sometimes requires medical management either through surgery or medication. Medication is often chosen because it's less invasive and more accessible to people, especially in lower income and rural areas where some people can't afford to miss work or travel to a doctor's office that can be hours away. The Texas district judge effectively ruled that mifepristone use should be blocked throughout the country. Just a few hours later, the Washington state court decided to protect access to mifepristone, and that caused nationwide confusion because people didn't know if or for how much longer they'd have access to the medication. The case went to the U.S. Court of Appeals for the Fifth Circuit, and then the Supreme Court prioritized the case, temporarily preserving nationwide access to the medication. Then, the focus turned back to the appeals court, who ruled that mifepristone should remain available but has to be prescribed in person before 7 weeks into the pregnancy. The Justice Department then quickly appealed that decision, so the next step is back to the Supreme Court. When making its decisions, the court often relies on precedents or previous judicial decisions from related cases. This process is called stare decisis, which is basically the Latin way of saying what they said. But precedents don't guarantee that the law is cemented. Some of the Supreme Court's landmark cases overturn precedents, like Brown versus Board of Education with school segregation and Dobbs with abortion access. Since one of the jobs of the Supreme Court is to clarify and interpret laws, during judicial confirmation hearings, it's common for senators to ask justices about their opinions on legal precedent. That's because senators want to know how radical the judges are and how much they'd change the court if appointed. And once confirmed, justices enjoy that sweet lifetime appointment. Lifetime tenures were meant to protect justices from worrying about the popularity of their decisions, and that can lend more protection to minority groups if they vote against the status quo. But that also means justices don't have to stick to what they say in their confirmation hearings. They can't lose their jobs just because they didn't keep their promises. And this is where people start to have questions about the Supreme Court. In the late 1800s, the average tenure was around 16 years, but that jumped up to 26 years in the late 1900s. That's a long time to have one job, especially considering the president can only be in office for 8 years. So because a presidency is much shorter than a Supreme Court tenure, appointing a justice is advantageous for a president because it ensures their political legacy after they left the White House. And longer tenures make it rarer for a president to appoint a justice. So if they get the opportunity, the confirmation process is often more politicized and competitive than before. And that's why a lot of people think that justices just reflect the views of the president who nominated them, like how Donald Trump nominated 3 conservative justices during his 4 years in office, bringing the court to a 6-3 conservative majority. This concerned many in the United States for a few reasons. First, it's a common misconception that presidents cannot appoint Supreme Court justices in their last year in office. This came up in 2016 when Antonin Scalia died and President Obama nominated Merrick Garland to replace him. The Republican-controlled Senate refused to vote on Garland due to something called the Thurmond Rule, which says that the Senate doesn't consider presidential nominees during election years. But that isn't an official rule and hasn't been consistently applied over the years. And then President Trump successfully appointed Justice Amy Coney Barrett shortly before the election in 2020. So, myth busted. Some people were also concerned that with such a strong conservative majority, every ruling of the Supreme Court would lean conservative. But it's also a misconception that justices always keep the same political views and vote according to those views. Many justices have changed their ideologies while on the bench, like current Chief Justice John Roberts, who started out more conservative-leaning, but has become more of a swing vote over time. In fact, we can measure a justice's ideology by comparing their votes to the status quo, not just off vibes. They're assigned a Martin Quinn score, which places justices on a political spectrum, with positive numbers being conservative and negative numbers being more liberal. As of 2023, Roberts hovers between 0 and 1, staying relatively centrist. And liberal and conservative justices don't always disagree. In 2021, most of the court's decisions were unanimous, or had just one judge dissenting. Justices agreed on things like expanding benefits and rights for student athletes. They also upheld religious freedom for a Catholic foster care organization that had a policy against licensing same-sex couples to be foster parents. Those things may not feel super reassuring for those concerned about the future of the Supreme Court, but they do show that the court isn't inherently politically divided. Most of the time, they can decide cases without relying on partisan arguments. But while justices might vote nonpartisan on smaller cases, when it comes to major ones, we see them consistently voting along partisan lines. And as the court becomes more involved in politicized debates, many people have started to view it as just another political body that's motivated by politics over law. But perhaps one final misconception people have about the Supreme Court is that there's nothing that can be done about it. There have been calls from some Democratic Congress members to reform the Supreme Court and bring more political balance, for example, by expanding the bench. Others, however, don't think this is a good solution, with some conservatives even saying it would harm the court. But in fact, there is precedent. While the court has held steady at 9 justices since 1869, before that, it fluctuated between 6 to 10 justices. And we already know that some of the Supreme Court's power wasn't outlined in the Constitution. So just as there was room to make changes in the Supreme Court throughout history, the future of the highest court in the land isn't written in stone. If you're enjoying Study Hall Power and Politics in U.S. Government and are interested in taking an online course and earning college credit, go to gostudyhall.com or click the button to learn more. Thanks for watching. See you next time.